Hi, welcome to the Hawaii Real Estate Report. I'm Scott Sakata.
And I'm Jeff Orig.
Today our guest is Thomas Wong of Devens, Nakano, Saito, Lee, Wong, and Ching. He's an attorney in the state of Hawaii, and he's also a state-appointed real estate commissioner.
Thomas, thank you for coming onto the show.
Oh, thanks, Jeff, and thanks, Scott. Nice to be here.
Can you tell us a little bit about yourself and how long you've been an attorney in Hawaii and so forth?
Okay, well, this being Hawaii, you know, everybody wants to know what high school you went. So I went to St. Louis High School before they had a good football team. But after that, went to the mainland college, came back here to law school here, graduated in 1981. So I've been an attorney, passed the bar, have been practicing with these law firms in one form or the other since 1982. Started as an associate, worked my way up to partner, and I'm a named partner now of Devens, Nakano, Saito, Lee, Wong, and Ching. Basically, our firm practices in the business commercial area, and my area of expertise, or what I practice in, is basically what's called collection law, where unfortunately if people owe somebody's money, I'm the one that goes and tries and collect that money for that individual company. I also do landlord-tenant matters, mostly representing landlords. I also do construction matters, representing sometimes the homeowners and sometimes the contractor. And I also, believe it or not, do immigration law, basically where people from foreign countries want to get visas to enter the United States. So that's my background, aside from being a foreclosure commissioner.
Okay. So, I mean, how did you get involved in becoming a real estate commissioner?
Well, how I got involved is, well, you know, as part of our practice, we have represented certain financial institutions in terms of when their mortgage needs to be collected. And what happens when you do that, there's a lawsuit filed, and I have represented those financial institutions in court. What is called our First Circuit Court here, there's usually a judge that is assigned what is called the foreclosure calendar. And you know, since I've represented these financial institutions over the years, after a while I built up my expertise. I felt comfortable enough to what you do, you apply to that foreclosure judge to see if you can be on the pool of what is called foreclosure commissioners. So I've been a foreclosure commissioner, I think, over 15 years, applying. I think at the time the judge was Philip Chun, who passed away a few years ago. The current foreclosure judge for the First Circuit is Judge Karen Blondin. Actually, she was a classmate of mine for law school, so I don't want to say how old she is. She's the foreclosure judge now. But basically what it is that usually you apply, and if the judge feels you're qualified, you're put on the list of foreclosure commissioners. And each, what is called circuit, which is basically each island, maintains a list. So there's one on Maui, which is the Second Circuit. There's one on the Big Island, which is the Third Circuit. And there's a pool, I guess, on the Kauai, which is the Fifth Circuit. Generally, it consists of attorneys or real estate agents. So if you two want to apply, you can. If the judge feels you're qualified, you're on the pool.
Do you know roughly how many, just on the First Circuit?
Roughly, my understanding, there's about 150 to 200 on this list. So the judge maintains a list, and eventually what happens is if she feels she needs a commissioner, there's a process of appointing someone.
I see. Let's actually take a break right here, and we'll bring it right back.
Okay, thank you.
Thank you. Okay, so Thomas, can you tell me what your role is during a foreclosure or bankruptcy?
Okay, well, let me explain the foreclosure first. You know, again, we're talking about a judicial court process. And what happens is, in the judicial court process, the financial institution has their legal counsel file a lawsuit. But to basically foreclose on this mortgage. But it also can be a condo association when unfortunately people have unpaid maintenance fees. They can file a foreclosure action asking that their unpaid maintenance fees, if they have a lien on that condo, be foreclosed upon. So the financial institution or the condo association files this lawsuit, and it basically then gets served on the parties. And at some point, they file what is called a motion for summary judgment. And what they're asking the judge to do is basically to, I guess, validate that they have a valid mortgage and ask the judge that they be allowed to auction off the property. If the judge agrees, then they're also asking that a commissioner get appointed. And if the judge, as I said, the judge agrees, that's what happens. The judge then goes through her pool or list and appoints a commissioner. And that's how we get involved. So we're appointed the commissioner. Excuse me. At the point we're appointed the commissioner, we don't represent any parties. Basically, we're representing the court. And our job at that point is basically to inspect the property, secure it as much as we can, and we have to schedule 2 open houses at reasonable hours, advertise that these open houses are going to take place, and then hold the auction. And then once we hold the auction, we basically, the last court process in this thing is that the judge will, what is called, confirm the sale. In other words, the judge will give his approval that the sale is valid.
And all this time, the current owner can still be living there?
It depends. Yes, if there's a current owner in there, I've had experiences where I have gone out there, and I know it's a tough time situation there, and then you have a family sometimes living there, but we have to ask them to, if they would cooperate with us and allow us to schedule the open houses. Sometimes they do, sometimes they don't. I've had situations where I've gone out there where the owner is threatening to kill me. And they want to kill the messenger sometimes. Yeah. In those situations, what we sometimes happens is we have to go back and ask the court, can we schedule this foreclosure without open houses? Or sometimes the lender asks us to basically get what is called a temporary writ of possession, which basically it allows us to go there with a sheriff or the police, and allows us to basically have the open houses with the police there present. Sometimes it happens. So yeah, if they're living there, even a tenant is living there, we kind of work around and that they are allowed to stay until the auction or eventually the sale takes place. If no one's living there, we basically bring in a locksmith and secure the property.
Oh, I see.
Okay, so can you briefly explain the difference between a judicial and non-judicial foreclosure? Maybe just go, what is judicial foreclosure first?
Yeah, if a judicial foreclosure is basically there's a lawsuit filed and it's going through a court process of getting the mortgage foreclosed upon. A lot of, if the general public looks at the paper today, there's a lot of ads for foreclosures. And I think a majority of the ads are what is called non-judicial foreclosures. And the banks and financial institutions are generally going that route more. And what a non-judicial foreclosure is whenever someone gets a mortgage, you usually are more happy getting the note and mortgage and buying your house. But if you read that mortgage document, there's usually a provision in there that says, in case you go into default, the bank can basically sell the property without having to go to court. It's called a power of a sale provision. So if that language is in the mortgage document, the court can basically foreclose without going to court. It's not only that the banks do, but if someone buys a condo, sometimes what is called the horizontal property regime also says that the condo association, if you have unpaid maintenance fees, they can get a lien, and they also can sell the property without having to go to court. So the non-judicial foreclosure is basically the lending institution or the condo association is foreclosing on its mortgage by having a auction without having to go to court. The question you might also have to follow, why does the bank, which one do they usually choose? And as I said, the banks are usually choosing the non-judicial foreclosure because it's a faster process. It probably takes generally 3 to 4 months by the time they put out these notices of default until they have the actual auction. Whereas in a judicial foreclosure, it can take 6 to 9 months or even a year to go through the whole judicial process. But one of the big differences is...
Can I stop you right there and we'll take a break
Okay.
and we'll pick this right up.
Thank you.
Okay, so Thomas, before the break you were explaining about the biggest difference between the judicial and non-judicial.
Yeah, one of the big differences is in a judicial foreclosure, what happens is that the bank is entitled, or the financial institution that is foreclosing is entitled to get what is called a deficiency judgment. And what that is, once the auction takes place, and say someone bids on the property and is a successful bidder, if the actual bid price is lower than what is owed to the bank can still get a deficiency judgment against the mortgagor or the people owing the money. So, if the bank is owed $250,000 and the actual auction, the bid price comes at $200,000, there's a deficiency of $50,000, which the bank can get that deficiency judgment against those mortgagors. And if they get a judgment in Hawaii, that judgment is good for 10 years, and it's also accruing post-judgment interest of 10% a year.
Oh, wow.
So the bank has a right to get that in a judicial foreclosure. In non-judicials, what it is, since there's no court action, the general rule of practice now is once the bank takes back the property, they're not entitled to get a deficiency judgment because they are exercising their remedy of just taking back the property.
So, okay, so the judicial, you mentioned the deficiency judgment. So let's say someone, another party bids $200,000, they get $200,000. I got a couple questions. But is there a confirmation hearing?
There's a confirmation hearing, yeah.
So if no one goes in and tries to bid it,
higher,
person gets $200,000. And so that $50,000, so that original owner of the property, they're still not off the hook. They still have to somehow, whatever.
Well, they're not off the hook for that deficiency.
The 50,000.
Yes, yeah.
So they still, the bank can still has 10 years to get that money back?
10 years, and they can exercise another 10.
Okay.
It was before why the banks were going deficiency is because some of these loans, what is called Fannie Mae and Freddie Mac loans, where they got their loans insured. And I don't know if it still applies, but the Fannie Mae and Freddie Mac rules before required the banks to go through the judicial process. If you get because I guess Freddie Mac or Fannie Mae is insuring the loans of those banks. So technically, after they go through the foreclosure, Fannie Mae and Freddie Mac is paying off that bank for that loss, but they were requiring banks go through the judicial process. I'm not sure if that applies now, and that's why some of the banks or most of the banks are going through what they call the non-judicial foreclosure process.
So I guess simple terms is the judicial, the lending institution is getting funds back, whereas the non-judicial, the lending institution is getting the property back.
Not necessarily. Well, they might not even get funds. What they, at the auction sometimes happen is that the bank is credit bids against their own mortgage, which means they don't have to come up with money to pay themselves back. But they can even credit bid lower than what their mortgage balance is and get a deficiency.
Oh, I see.
So that's one of the big differences between the judicial and non-judicial.
So if someone's property does go into foreclosure and the foreclosure process has begun, can they still get their property back?
Yes, they can. I mean, there's nothing, there's some states there's what is called a right of redemption, where the borrower has a right to redeem the property for a certain period of time. Hawaii doesn't have anything on its books, but I've seen where the foreclosure process has started, and if the borrower wants to try and work some things out, the judge, being that someone may be losing their house, has given the borrower some time to see if it works out. So in a sense, even though there's nothing legally like a right of redemption, during this court process, if you're trying to work things out, we've seen it happen where someone can still save their house. I think that usually happens until there's the auction, and if the auction has a third party buying it, that's probably when your right is probably foreclosed upon. So until that period of time, if something can be worked out, I would tell any borrower, try and do it as best you can.
Okay.
Can you assist the person that's in default?
I can assist if I'm not acting as a commissioner, and I have done it. But if I'm acting as a commissioner, again, we don't represent any of the parties, and we're supposed to try and stay neutral. But so the foreclosed party should try and either get help from someone else or legal counsel.
Okay. Okay. Well, we'll be right back after this.
Thank you.
Okay, Thomas, so, part of being in real estate, people looking to buy real estate right now, and they're always asking us, well, we're interested in foreclosures. So, if someone is interested in foreclosures and purchasing a foreclosed property, what are some of the things they should be aware of?
Okay. Let me talk from it, I guess, from the standpoint of what happens in the non-judicial and a judicial. Okay. But my only caveat is if you're a first-time home buyer, I wouldn't recommend this process because it happens very fast. And so there's not a lot of time to do your due diligence. On a non-judicial foreclosure, if someone is interested, if you notice the ads in the paper, there's basically no open houses, and they just have the auction. So you have no opportunity to at least even view the property. And what happens at the auction, if you notice in non-judicials, you have to come up with the full amount of the money. Which means there's no like deposit. So yeah, if the mortgage that is being foreclosed on is $500,000, you got to come up with $501,000. So that's the thing with non-judicials. In judicial foreclosures, yes, we have open houses, but it's like maybe for 3 hours on a Saturday, and for you to do the due diligence is not much time. So if there's any structural damage with that property, you're buying that as is. It doesn't give you a lot of time to inspect that whole property. But if you still want to bid, you can. And at the auction, in judicial foreclosures, you're only required to put up 10% at the time of the auction. And it has to be like cashier's or certified check. So if you find that dream home that you want, if you're going to bid $200,000, you have to have at least a cashier's or certified check of $20,000. But here's the thing, sometimes people don't know in judicial foreclosures, even if you're the successful bidder at the auction, as you mentioned, Scott, there's a motion to confirm the sale. What I tell people that are the successful bidders, it doesn't mean you're going to get the property, because the judge has the final say. So after the auction takes place, we file what is called a commissioner's report and say like Scott Sakata was a successful bidder. But the attorney that represented the bank then files this motion to confirm the sale, which is a hearing date before the judge. Usually happens maybe about 30 to 40 days down the line. And at that hearing, if someone wants to bid 5% higher than what the bid price was, the practice here is the judge reopens the bidding. So if the successful bid price was 200,000, if my math is correct, if somebody wants to bid 210,000, we reopen the bidding. And what it means, we go outside and have the bidding process done all over again. It doesn't mean that the bid price after that has to be 5% higher. It's just at that opening bid.
Oh,
So it can go 210 and 211,000.
so there's can be another person in there, third and fourth party.
Yeah, so most Akamai foreclosure people know that the action really takes place at the motion to confirm the sale, that hearing, and they usually hold back and don't bid until that hearing takes place.
Yeah, well, actually, I had a client a couple years back. We bought a foreclosed property, and he was the winning bidder, and we had to wait and wait and wait before the confirmation hearing, and I mean, he lost it because someone came in and bid
So
over it.
sometimes they hold back. So how you find out? You call up the commissioner and find out when that hearing date. And my advice is that's the time to bid. So if you're a successful bidder, but at that time, usually you have 45 days to close. So you got to get your financing all done or at that time. And if you don't close, you could lose your deposit.
Oh, wow.
The judge can say because of costs and things. So
Any extensions allowed in that type of
I've
situation?
had where they've asked, and the judge, I think, has granted it. But at some point, if because you're not getting your financing, they're going to say no, and there's a possibility you can lose your
10%.
10% deposit. Will you lose the whole thing? Maybe, maybe not.
Oh, wow.
So it's a fast process, not designed for the first-time home buyer.
the first-time home buyer and the faint of heart. So, well, I mean, we're out of time, and again, we just want to thank Thomas for coming by and giving us a brief explanation of the foreclosure process and being a commissioner. So, my name is Scott Sakata,
I'm Jeff Horrig.
and we'll see you next time.
Thank you.